Good afternoon.
Good afternoon, Your Honor.
Good afternoon, Judge.
Afternoon.
She getting the inmates now. That's Dalton that's in the chair though, Judge.
Oh, okay. I saw her kind of running to the back. That's position 2.
Yeah, whenever you get your speak.
Okay.
And by the way, the reset date for the SAP calendar is May 4th.
May 4th.
Thank you, Ms. Bridgewater.
You're quite welcome.
In Your Honor, I'm going to be handling the cases today. So all of them.
All of them. I was going to say all of them. Okay.
Yeah. Not that many. So I let the other attorney off the hook.
Okay, I hear you. All right, if we're ready to start, I will get going. Good afternoon, ladies and gentlemen. This is the Fulton County State Court Expedited Accusations calendar. I'm Judge Regina Mincing, and we're going to start this calendar today for Saturday, April the 22nd, 2023. This is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before state court judge, so we are able to address several matters, including bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. I'm going to also provide you, which you may have already heard of, a reset date for the state all-purpose calendar that will be May the 4th. Also, I want to begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube, so govern yourselves accordingly. I want to also remind the defendants that you do have certain constitutional rights. The first being that you have a right to representation. At this point in your case, most of you, or all of you rather, should know who your attorneys are at this point. Also, you have a right to remain silent. Remember that anything that you state about the facts, the circumstances, or the occurrences of your case can and will be used against you. Obviously, solicitors are here and they're listening. So listen to your attorneys. All right, I understand the first case we have is position 2, Dalton. Is that correct, deputies?
Yes, position 2, Dalton.
All right, thank you. This is 23 CR 002490J. Angela Dalton, you're charged with 1 count of theft by taking. That offense date is April the 21st, 2023. Pre-trial?
57 total. She got an open case in Superior Court, 21 SC 178393. It's for PI and a vice related charge. 2023 shoplifting, 2022 burglary dismissed, 2021 shoplifting, 2020 probation and a FTA, 2018 burglary conviction, and 2016 and 18 probation. That's all I put on here.
All right. Thank you. All right. Deputy Falk?
Yes, Your Honor. This happened on the incident date that Your Honor's already previously stated at 887 Drummond Street, Southwest in Atlanta. Mr. Biondi Copeland was in the process of cleaning his yard and left his weed eater and track lights on his front porch. When he returned to the front of the house, he noticed the items were missing. He was then alerted by a neighbor that a person then later identified as the defendant was on his porch taking the items. He went to his Ring doorbell, saw the defendant grabbing the items at around 7:01 a.m. He then located the weed eater in an open field, called 911. When the police arrived to that location, that open field, they observed the defendant as a passenger in a vehicle at that location, and they were able to retrieve the weed eater and place the defendant under arrest. We did have an opportunity to speak with Mr. Copeland. He stated he does not know the defendant, and he saw the defendant on his Ring doorbell stealing his weed eater and floodlights, the value of which were about $150. He said he got the weed eater back, but not the floodlights, and he believes the defendant may need a MH or ADET evaluation. He stated he wants no contact, the defendant to stay away from his home located at 27 Booker Street, Atlanta, 30314. So the state's recommendation on this case is a $500 surety bond. Stay away from 27 Booker Street, Atlanta, Georgia, 30314. No further contact with Biondi, that is Biondi Copeland. No alcohol, drugs, or weapons. The reason for the surety bond instead of a signature bond is due to the defendant's extensive history, including burglary convictions. That's all for the state.
All right. PD?
It's me, Your Honor.
Okay, Ms. Bronstein, thank you.
The public defender's office is representing Ms. Dalton for purposes of bond today only. She is 44 years old. She is originally from Atlanta, has lived here her whole life. She lives with her uncle. Her father lives nearby. She has family in the area, certainly has ties to the community. She did do some college at a community college and studied small business, and she utilized that. She works for herself. She cleans houses, and she's been doing that for the past 13 years. Your Honor, I do want to let the court know that Ms. Dalton, she does have health issues. She is sick right now. She's in a lot of pain. She talked about back pain. I did actually speak with her very early this morning before anyone else due to her pain, so she wouldn't be sitting around. We would be asking for that the court consider a signature bond in this case.
All right. I'm going to order the $500 surety bond. I'm going to order a stay away from the 27 Booker Street in Atlanta. I'm going to order no further contact with the victim, Biondi Copeland. I'm going to order no drugs, alcohol, or weapons except any drugs prescribed to her, but no weapons and other drugs while on bond. I'm going to, and I've heard the state's request on an ADET or an MH. Certainly, we want social services to meet with her, or talk to her, or behavioral health. Maybe we can just do that. I don't know, Ms. Dalton, if you had any indications of anything more serious.
Not from my conversations with her.
Okay. All right. Just make sure that behavioral health can talk to her before she is released, or she makes bond, and see if there's any services that can be provided to her. And I think that will be it. Anything else, counsel?
No, Your Honor. And Mr. Copeland stated he would not be here, but just out of an abundance of caution, I can see everyone else's name except for iPhone. I just want to make sure that's not Mr. Copeland.
Okay. iPhone, don't know who that is. If they could figure out how to put their name on, that would be helpful. But just to make sure, is Mr. Copeland on the Zoom call? Mr. Copeland. All right, don't think he's here. Thank you. All right, that will conclude this matter.
Next is position 7.
All right, this is 23 CR 002495A, James Legrette. I'm charged with 1 count of simple battery, family violence, a 2nd count of simple assault, both with the offense date on April 20th, 2023. Pre-trial.
Third arrest. Last arrest was a 02 burglary harassment conviction. That's all.
All right, and Deputy Falk.
Yes, Your Honor. This happened April 20th at Mimosa Boulevard, Magnolia Street. Julia Ulrich, who is a witness, called 911, advised dispatch there was a drunk male, later identified as the defendant, hitting who the Miss Ulrich believed to be his wife. The 911 dispatch then received multiple other calls coming in stating the defendant had shoved what they believed again to be his wife into a car and slammed her head into the car several times. So there were multiple 911 calls prior to the officers going out there. When they arrived, they spoke with Miss Erin Dolphy, who was, according to the officer, extremely intoxicated and claimed nothing physical had happened. However, the officers spoke to 2 witnesses who were on scene as well. They also spoke with Nicholas Workman, who is the 2nd victim in this case, who stated he tried to break up the physical altercation that was occurring between the defendant and Miss Dolphy, and the defendant took a fighting stance against Mr. Workman, which caused him to fear a violent injury, and he did in fact want to press charges. I believe Ms. Dolphy is here on the line. We are also going to sound for Mr. Workman. The state is gravely concerned about this incident, being that there were multiple witnesses to what happened and also multiple 911 calls. Enough people were alarmed about this that several people called 911 to try to get help for Ms. Dolphy. And so the state's concern about how this was, what happened at this incident gives rise to our concern that there may be a repeat offense. For that reason, the state is recommending a $5,000 surety bond. There's already a $1,500 surety bond set on the simple assault. The state is going to ask for a $3,500 surety bond on the simple battery family violence. No further contact with Miss Erin Dolphy or Mr. Nicholas Workman, no alcohol, drugs, or weapons, and a domestic violence intervention program. I believe, according to the warrant, Mr. Legrette and Miss Dolphy do live in the same household. That is all, Your Honor.
All right.
Good afternoon, Your Honor. Ryan Walsh here for Mr. James Legrette. He's 54 years old. As you heard, his last incident was in 2002. His life has completely changed since then. He moved down here from New York as part of his relationship with Miss Dolphy. He works construction. He lives with them, with her and her children. She's present on this call. And she'd like to make a statement regarding the facts surrounding the incident and her desire for JB to return to their home with her and her children. They were out in downtown Roswell on Thursday night. They were leaving. I think Miss Dolphy will tell you she was having a hard time leaving. She fell. I think she'll state that. She'll state that he never laid his hands on her. He's never been violent with her. And she fell again, and then Jamie decided it was better for him to try to get the car to her because she was having a hard time. You can see her on the video. It does not look like her head was repeatedly slammed multiple times into a car. There's no mention on the warrants of any damage to any vehicle. They didn't notice any injuries to Ms. Dolphy at the time of the incident. Again, I'm going to let her speak to that. He did, and I think she will admit they were having an argument about the difficulty in getting to the car, but there was no violence associated with that argument, and that may have been what caused some attention to be brought upon them. The last thing I want to talk about is that I know her children also have no issue with him. They love Jamie, and they want him to be around. I'm going to ask for a $2,000 bond on the simple battery charge, Judge, with a no violent contact provision, as we provide the information necessary to resolve these charges in the appropriate manner. And I was also asked, and I think Aaron can provide this as well, that her ex-husband's, just in case Jamie has an issue contacting her later today, his number is 585-298-0980. I can provide that in the chat if he needs somebody to get in contact with later today, but we'd ask the court to put in a no violent contact provision.
All right, make sure I understand. I got lost a little bit in the names. Who is Julia Orek?
Julia Ulrich was one of the people that called, one of the several people that called 911 in regards to this incident.
All right. And as far as the defendant, he resides with the witness who's on the call, and I'll speak to in a second, and that's Erin Dolphy.
That is correct, Your Honor.
All right. And she is a victim as well as Nicholas Workman.
That is correct, Your Honor.
And Your Honor, I don't believe Mr. Legret knows Mr. Workman or would have any issue with a no contact provision being put in place again with him. I don't think there was any prior relationship. My guess is he was startled when he showed up in his face, and he probably tried to defend himself. I think the facts will come out on that in the future.
All right. Miss Dolphy, would you like to address the court today?
You need to unmute yourself, Aaron.
Am I unmuted?
Yes, and then I think you've taken your camera off. I have to be able to
I'm
see.
sorry, I don't normally do this, Your Honor.
Okay,
Let me see.
there you go.
Okay,
All right, do you
can
wish
you
to
still
address?
hear me?
Yes, do you wish to
Yes,
address?
ma'am, but somehow I've taken the speaker off and I can barely hear you. Can you hear me okay?
I can hear you okay. Can you hear me any better?
No.
You would have to be able to hear my questions.
Okay, I can hear. How about now?
Yes,
Okay, better, much better. Thank you.
okay. All right, if you wish to address the court today, I'm going to need to swear you in. Can you raise your right hand? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right, you can put your hand down. What would you like to tell me about this incident?
I would like to make sure that the court is aware that Jamie has never, ever frightened me in a violent manner, been violent, including the night of that incident. I remember all of the detail. I was very intoxicated, yes. I did need help getting back to the car, in which he helped me the entire way. I fell down several times, and he did such a good job helping me that I don't even have scrapes on my knees. I did fall into the vehicle, but he never pushed me into the vehicle, and he never slammed my head into the vehicle. I had no marks on my face. I had no headache. I believe in the report, it was noted that there were no marks on my face, no bruises, nothing.
Okay,
He has never touched me. It would be a huge financial and emotional burden on our family to not have him back with me, and I would like him back home.
all right. And are you in fear of Mr. LeGret?
No, not ever, not now.
Okay. All right. And do you all have children together?
Not together.
Okay. How old are your children?
I have a daughter who will be 11 in November. I have a 13-year-old son and a 15-year-old daughter.
Okay. All right. Any cross-examination, Deputy Falk?
Yes, Your Honor. Hi, Ms. Dolphy. How are you?
I'm good. How are you?
Doing well. So your attorney or the attorney for Mr. LeGret stated that the two of you were arguing that night. Can you tell us what the argument was about?
There was no argument. I was never upset with him. He was never upset with me. As I've told you, I needed assistance. What happened that night was I hadn't eaten very much. I became too intoxicated quickly, and I said, we need to go. He helped me a very long way from Ips all the way up there where we were going to the Presbyterian Church of Roswell. It was a very long way, and I kept falling. I can only speculate that if I were him, maybe I would have been frustrated at me falling and him trying to help me and asking to help me. And from a distance, bystanders may have thought that he was hitting me or pushing me, but I was falling all on my own and he was helping keep me up.
So you're saying that Mr. Walsh may have just been mistaken when he said that there was a verbal altercation that occurred.
I do not remember any type of verbal altercation where I felt like he was angry at me. We were talking, I'm sure, but it was never where I felt frightened or upset by his words.
Okay. And you recall someone trying to intervene while he was helping you?
I do, and I was confused. Again, this is all coming from a state of intoxication where I am having trouble even walking. I do remember, and I was confused why people were coming over in a manner that seemed that they were concerned.
Okay. So it is your statement that multiple people who called 911 to say that a physical altercation between you and the defendant, they were just all mistaken about what they saw that night. Is that correct?
I know what happened, and I know I was never, ever pushed, shoved. My head was never, Jamie has never touched me ever in a way other than lovingly. He's never, ever touched me in a physical manner that was violent or threatening, including that night.
Thank you, Ms. Dolphy. That's all for the state, Your Honor.
All right. Any cross-examination, Mr. Walsh?
So, Judge, I just want to make sure it's clear for the record that when I said altercation, I just meant the frustration with getting her to the car. I might have used a better choice of words there, but that was my intent with that statement earlier.
Okay. All right, I'm going to order the $5,000 surety bond. That will be $3,500 on the simple battery, $1,500 on the simple assault, for a total of $5,000. I am going to order no further violent contact with the victim, Aaron Dolfrey. And I'm going to order no further contact with the victim, Nicholas Workman. State, I did not hear a request, or did I, for a stay away?
We did not have the address of Ms. Dolphy at the time, Your Honor. So that's
All
why
right.
we simply asked for the no further contact.
All right, if Mr. LeGret makes bond and goes back to stay with Ms. Dolfrey, there's a no further violent contact. And hopefully that will definitely be the case while Mr. LeGret is on bond. No drugs, alcohol, or weapons while on bond. And that's all our order at this time.
Thank you, Your Honor.
Thank you, Your
All right,
Honor.
thank you. All right, thank
Be
you.
excused.
Yes, you may.
Mr.
Thank
LeGrand,
you.
we'll take care of everything. Start the process. Have a good day. Thank you, Judge.
All right, thank you. You too.
Position 1,
This is 23 CR 002489A, Marlon Chavaria Gonzalez, charged with 1 count of criminal trespass, offense date April 20th, 2023. Pre-trial?
2022 battery, disorderly intoxication, that was out of Florida, and a 2010 occupying property without consent out of California. That's it.
All right, and that's it. All right, Deputy Falk.
Yes, Your Honor, there's a $1,000 surety bond already set. The state is agreeable to reducing that to a $3,000 signature bond through the jail. Stay away from the Gaslight at 890 Atlanta Street, Roswell. No alcohol, drugs, or weapons. The defendant was at that location on the 20th. He was previously criminal trespassed on October 21st, 2022 by Alex Kazemi, who is the manager. And when he was confronted by the officers, he stated he knew he wasn't supposed to be there, and he was trying to explain to his friends that he needed to leave. That's all for the state.
All right. And so that's a $3,000 signature bond through the jail and no stay away or anything.
No, I stay away from the Gaslight at 890 Atlanta Street in Roswell. And no alcohol, drugs, or weapons.
Thank you. All right.
No objection, Your Honor. And just for the record, the Public Defender's Office is just representing him for purposes of bond today.
All right, I will order that $3,000 signature bond through the jail. I will order a stay away from the Gaslight at 890 Atlanta Street in Roswell. I'll order no further contact. And I don't know, was that the victim, Alex Kaminsky?
Well,
Or
Your Honor, that's
No.
the manager of the Gaslight. As
Oh.
long as he stays away from that location, we don't need a no further contact.
Okay, just to stay away from that location.
Yes, Your Honor.
I hope Mr. Chavaria Gonzalez understands that this time. And I'm going to order no drugs, alcohol, or weapons while on bond.
And Your Honor, just if I can make it clear to him that that includes the property, not just the inside of the building, okay?
Right. We just stay away from the perimeter as well as the inside, outside and in, and not to be at or near that location. Is that clear? Is there any question? Okay. All right, that'll conclude this matter. Thank you.
You got the signature bond. That's what we were going for. So
I don't understand what it means 2,000.
Let
me know money, we'll go home. Okay.
If you default, or if you go back there and you're arrested again, then your bond will be that 3,000. But right now it is a signature bond, but that amount would be the amount that we would
Okay, thank you, Your Honor.
use if we brought you back. Okay.
Thank you. Thank
All
you,
right.
Ms. Swanson.
Position 3,
This is 23 CR 002492C, Rashad Dowdy, charged with 2 counts of giving false information to a law enforcement officer and a 3rd count of driving while license suspended or revoked. The offense date is April 22nd, 2023. Pre-trial.
21 total. On probation. Theft by taking, burglary in the 2nd out of DeKalb County. I also got a criminal damage to property, possession of tools, conspiracy to commit a felony out of Cobb. Probation. We got another burglary out of Clayton County. 2017 criminal damage to property, first offender. 2017 suspended license, given false name, NOLO. 2017 failure to appear, simple battery, DV. Criminal damage to property conviction. 2016 theft by taking conviction, simple battery conviction. That's it.
All right, Deputy Falk.
Yes, Your Honor. This defendant is currently on a $2,000 surety bond, 1,000 per count. We added a count of giving false information, one for the date of birth, one for the name. We are agreeable to reducing this to a $3,000 signature bond through pretrial services, 1,000 per count, and release him to whichever foreign hold wants him first, DeKalb, Clayton, or Cobb. No alcohol, drugs, or weapons. This happened yesterday this morning at 1:15 a.m. at 2 Park Plaza. The officer conducted a traffic stop due to a suspected terroristic threat. The defendant acknowledged the reason for the stop, but claimed that the manager was lying about the incident. When he was asked for his driver's license, he said he didn't have one. He also gave the name Jalen Jackson and the date of birth of July 4th, 2000. When he was relocated then to a fingerprint scanner when that name and date of birth didn't match him in the photo, and it revealed the defendant's name and date of birth, his real name and date of birth, and that he had a suspended license due to FTAs from 2021 and had several warrants outstanding. That's all.
All right. PD Armstrong.
Yes, Judge, no objection to the signature bond through pretrial services to release to hold.
Judge,
All
can you
right.
send that through the jail, please?
I'll send it through the jail.
Yes.
Okay. That'll be a $3,000 signature bond through the jail. And obviously pending whoever comes to get him first on the 3 holds. No drugs, alcohol, or weapons while on bond. And is that it, Deputy Falk?
Due to his history, we object to a signature bond through the jail, but that is all.
Okay. All right. That will conclude this matter.
Position 8.
This is 23 CR 002497J. Dedrick Martin, charged with 1 count of criminal trespass and damage to property, 2nd count of criminal trespass, 3rd count of willful obstruction of a law enforcement officer. The offense dates are April 21st, 2023. Pretrial.
31 total. You got an open case in Superior Court, computer theft. That's 22 CP 206097. Also criminal damage to property trespass. 22 CP 206098. Got a 2023 theft by unlawful taking, theft of property. 2023 disorderly conduct, theft by unlawful taking, conviction. Those are the Pennsylvania. 2022 probation, failure to appear. 2020 trespass. 2018 probation. 2018 shoplifting conviction. 2016 and 18 probation, and a 2014 failure to appear.
All right, Deputy Falk.
Yes, Your Honor. This happened yesterday at around 2:50 p.m. at 617 Eleanor Place Northwest in Atlanta. Freddie Simmons, who is the homeowner at that location, arrived home, saw that a window next to the door frame was shattered and a metal security door was bent. He then went upstairs to the front door and saw the lockbox hanging from the doorknob was missing, and the locks had been tampered with, and the locks were missing from the back door as well. Simmons then located the defendant, who was sleeping in the bed of one of his bedrooms. He woke up the defendant, told him he had to leave, and the defendant stated, "I am not leaving, you're going to have to kill me." The two of them began fighting, and this fight then took place outside and spilled into the outside area. Mr. Simmons, the homeowner, then left and walked up the street to his daughter's residence to call 911. And when he went back to his house, he saw the defendant in his backyard and left again. The officers then arrived. Mr. Simmons flagged them down and pointed out the defendant, who then ran. The police chased him until he was detained, which is the basis for the obstruction. Nothing was taken from the residence, but we did have an opportunity to speak to Mr. Simmons. He stated that he does not know the defendant. When he got to his house, he noticed the window was broken, the doors and the locks were all missing or broken, and that 2 of his burglar bars were broken as well. And that when he went inside, he did concur with the report, which says the defendant was asleep on one of the beds, stated that he was going to have to kill him, that they then began to fight. He went outside where the defendant then threatened to kill him. And then Mr. Simmons ran, left, went to his daughter's house to call the police, went back to his house, but the defendant was still lurking on his property, and then went to his daughter's house and waited until the police arrived. He did state he would like no further contact whatsoever with this person, and that he would like him to stay away from his home at 617 Eleanor Place Northwest in Atlanta, Georgia. The state's concerns here are the defendant has an outstanding warrant from Pennsylvania for larceny from April 18th of 2023, a disorderly conduct conviction from March of 2023 in Pennsylvania, and 2 counts of theft from March of 2023 as well. He also has 2 open cases in the felony division, one for computer theft and one for criminal damage to property in the 2nd degree and criminal trespass. So we do have concerns on 2 fronts. One, that he is not a good risk of coming back to court, being that he has outstanding warrants in Pennsylvania and an outstanding case and convictions in Pennsylvania as recently as April of this year. And the secondly, that with the computer thefts and the criminal damage to property in the 2nd degree and criminal trespass, he is a risk of reoffense, being that he's already out on 2 different felony bonds, and this is his 3rd open case. Our final concern is that he's a risk to the community. Mr. Simmons does not know this man. And for him to be in his house, and then when Mr. Simmons confronts him and tells him to leave, for it to turn into a physical altercation to get this man out of his house, it puts Mr. Simmons at risk and puts anyone he encounters at risk. For that reason, the state's recommendation is a $4,000 surety bond, $1,500 for each count of criminal trespass, and $1,000 for the obstruction of an officer. We are also asking no further contact with Mr. Freddie Simmons, stay away from 617 Eleanor Place Northwest, no alcohol, drugs, or weapons. We'd also recommend, due to the history, possibly a BHET. Thank you.
All right, PD Armstrong.
I agree that a BE, I can't talk, VHET, what, you know what I'm trying to say, I'm sorry, I haven't had enough coffee today. We would like that too. And at this point, Your Honor, my client reports that he is a trucker, so we're concerned he's going to lose his job if he remains in custody. Fully recognize his criminal history though. And my client reports that he has 2 daughters, one is 14, one is 11. The 14-year-old has significant health concerns, so we're asking Your Honor to consider a signature bond on each count so he can be out to take care of his daughter. Nothing further.
All right, I'm going to order the $4,000 signature bond. I'm sorry, surety bond. $4,000 surety bond, $1,500 on the first 2 charges, $1,000 on the obstruction, for a total of $4,000. I'm going to order stay away from 617 Eleanor Place Northwest in Atlanta. No further contact with the victim, Freddie Simmons, and no drugs, alcohol, or weapons while on bond. I'm going to order the BHET as well. And I think that is it. Anything else, counsel?
No, Judge, thank you.
All right, thank you.
Thank you, Your Honor.
Position number 9.
9, okay.
What is that?
No.
Is 23 CR 002496D, Quintarius Riley, charged with 1 count of battery, family violence, a 2nd count of criminal trespass and damage to property. Offense date 2/26/2023. Pretrial.
His 9th arrest on probation for ag battery, false imprisonment. 2018, they gave him 6 months to serve. Probated 9 years, 6 months out of Douglas County. 2020, 2019, probation violation. 2018, failure to appear. 2016, trespass conviction. That's it.
Deputy Falk.
Yes, Your Honor. This happened February 26th at 4401 Green Springs Road. Mary Haynes called police and stated her daughter's boyfriend threw a scooter, a child's scooter, in through the rear window of her vehicle, causing damages. Officers then spoke with Mary Hines, who stated that the defendant became angry with her daughter, Ocean Hines, and threw the scooter and damaged her vehicle, which was witnessed by Mary Hines and other family members. Officers then spoke with Ocean Hines, who stated that the defendant, her boyfriend, became angry with her and stated he was leaving. She told him that was fine. She then thought he had left. Miss Hines stated she was in the bathroom and the defendant entered, attacked her by hitting her in the head with a plate of food and then hitting her several times. Officers observed abrasions and bruising to the back of her neck, and Ocean's brother heard the commotion and tried to stop the defendant. According to all the individuals at the residence, the defendant did reside in the same home as Miss Ocean Hines. Again, we had observed the state's main concern in this matter is the defendant has a 2018 aggravated assault, false imprisonment, criminal damage to property in the second degree out of Douglas County that he's currently on probation under first offender for, as well as a FTA out of 2018 in Douglas County, and a probation violation in 2019 in Douglas County and 2019 and 2021 in Douglas County. For those reasons, we are concerned about the risk of reoffense and the danger to the victim in this case. So we are requesting a $6,000 surety bond, $5,000 on the battery, $1,000 on the criminal trespass, and that is in large part due to the already outstanding aggravated assault, which he's on probation for, which shows a propensity for violence. We are also asking for a stay away from 4401 Green Springs Road, no further contact with Mary Hines or Ocean Hines. First name's common spelling, but the last name is Hynes, and no alcohol, drugs, or weapons. We would also like to sound for Miss Mary or Ocean Hines and see if they're here.
All right, Mary or Ocean Hines. Mary or Ocean Hines. All right, don't think they're on the Zoom. PD Armstrong.
Yes, Judge, thank you. My client is from Atlanta. He has a high school diploma from Frederick Douglass High School. He's been working in a warehouse where he makes enough money so that we're only representing him today. He's going to have to hire his own attorney once he gets out, and we've had that conversation. He lives with his mom, recognize the criminal history, but we're asking Your Honor to consider a signature bond or very low bond in this case so my client can continue working. Thank you.
All right, I'm going to order the $6,000 surety bond. That is $5,000 on the battery, $1,000 on the criminal trespass. Going to order a stay away from 4401 Green Springs Road. No further contact with the victim, Mary Hines, and the other victim, Ocean Hines. No drugs, alcohol, or weapons while on bond. Anything else, counsel?
No, Judge, thank you.
No,
Okay.
Your Honor, thank you.
Who do we have next, Deputy?
Position 10 and 11.
Huh? We're going to call both cases. The first case is 23 CR 002498J. Darius Spellers, charged at 1 count of simple battery family violence on December the 3rd, 2022. Second case, 23 CR 002499J. Darius Spellers, charged at 1 count of criminal trespass and damage to property. The offense date is December the 14th, 2022. Pre-trial?
16 total. Open simple battery DV, simple assault DV, trespass, obstruction as well. That's 22 CR 006777J. 2017 ag assault conviction. 2012 theft by receiving. Possession of a firearm by convicted felon. Possession of a firearm during the commission. Obstruction, fleeing an officer, theft by receiving, auto All those were convictions. That's it.
All right, Deputy Falk.
So, Your Honor, of note is in that 22 CR case that is still currently open. The defendant was given a $6,000 surety bond on that case, $5,000 on the simple battery, family violence, and $1,000 on the obstruction of an officer, as well as ordered to have no further contact with the victim, Melissa Sconiers, who is the victim in both of our cases today, and a stay away order from 3000 Stone Hogan Connector. He was also ordered to have third-party transfer of the children. That order was signed October 10th, 2022 by Judge Morrow, and the defendant was released on October 14th, 2022. That is of particular note because these events happened about 2 months, less than 2 months after he was released on that bond by Judge Morrow. The first incident happened December 3rd, 2022 at 3000 Stone Hogan Connector, which was the address he was told to stay away from. And in that case, Melissa Sconiers agreed to let the defendant, who is the father of her children, come to visit their 7-year-old daughter. Ms. Sconiers stated she was upstairs. The defendant asked if he could use her vehicle. She said no, and the defendant hit her on the right side of the face and struck her multiple times with his fist and pulled off her wig. He then left with her vehicle, which was later impounded. Ms. Sconiers sent us the receipt where she had to pay $231.75 to get her vehicle out of impound 3 days after this incident happened. The next incident was December 14th of 2022, again at 3000 Stone Hogan Connector. Miss Melissa Sconiers stated she was asleep when she heard her window shatter. A rock landed on her bed and some glass shards landed on her, but she was not injured. She then stated she saw the defendant running from the scene, and she had been receiving phone calls from the defendant saying she needed to get rid of her current boyfriend or he was going to cause her some harm. The defendant also later admitted, and this is in either the warrant or the police report, later admitted in a text message to doing the damage that was complained of in the December 14th incident. We have had an opportunity to speak with Ms. Sconiers. She stated that she concurred with everything in the warrants. She did state she sustained some bruising to her body and a swollen eye from the December 3rd incident. She gave us that receipt for having to get her vehicle out of impound. And on the December 14th incident, she did concur with the events that happened that were in the warrant as well. The fact remains the defendant's already had a conviction for aggravated assault. He's currently out on a $6,000 bond for simple battery, family violence, and obstruction involving Melissa Sconiers already. In 2 months after he gets out on that bond, he is then back at her home, abusing her and terrorizing her by throwing rocks through her window. She stated unequivocally that she wants no contact with him whatsoever. She has moved to a new location. She doesn't even want to put the address on the bond conditions because she wants no way for him to find her. So at this point, we are extremely concerned for the safety of the victim. We are asking for a $4,000 cash bond on the family violence simple battery, a $1,000 cash bond on the criminal trespass for a total of a $5,000 cash bond, no further contact with Melissa Sconiers, stay 200 yards away from her, do not contact her via email, text, third party, or social media, and no contact with the children at this time. Ms. Sconiers is here on the line and we would like to sound for her. Thank you, Your Honor.
Okay. All right, Ms. Sconiers, Melissa Sconiers. Can you unmute yourself? The red little microphone.
Yes, ma'am.
All right, do you wish to address the court today?
Yes, ma'am.
All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Are you in fear of Mr. Spellers?
Yes.
Okay. You don't want to be around him, is that correct?
No.
Okay. You weren't residing with him or were you residing with him at the time of these incidents?
No, he has his own place. No.
Okay. And he's your child's father?
No, actually, he just helped me took care of her. But no, we don't have no kids together.
Oh, no kids together. Okay.
Mm-mm.
All right. Anything else you'd like to say to the court?
No, I don't want him to stay away from me, like, and stop contacting me. Like, Darius is a very violent person, and he just needs to stay away from me. Like, He done, it's been so many incidents back to back with him, and it's ridiculous.
Okay. All right. Any cross-examination, Deputy Falk?
No, Your Honor, but the state would like to apologize for misrepresenting that they shared children. I was under that assumption based on the previous bond order and the fact that he was coming to visit the 7-year-old.
Okay. All right. PD Armstrong?
No cross exam.
All right. You can go ahead and present. You can mute yourself, Miss
Thank you.
Schoner. Is it Sconier?
Conyers.
Sconiers. I'm sorry. Yes. Thank you for your time. All right. Okay. Go ahead, PD Armstrong.
Thank you, Judge. Mr. Spellers works full-time at a tire shop. He no longer lives near or around where the alleged victim lives. I did provide the court with his new address I submitted to Mr. Jordan and Mrs. Holly Bridgewater. He is engaged. His new fiance is 4 months pregnant, and he wishes to have nothing to do with Ms. Conyers. It's based on my client's recitation of what allegedly happened. It differs wildly from what has been presented to Your Honor. In fact, it's our position that Melissa hasn't left him alone, and all he wants is for her to leave him alone. And quite frankly, I don't know why she would be reaching out to him since they don't have any kids in common. He just wants to move on with his life with his new family and keep it moving, keep working. He's extremely worried he's not going to get to go to work on Monday, and if he loses his job, that would be absolutely dire for his growing family. We recognize the criminal history. We recognize any concern for repeat offense and any danger that the state might assert that Melissa would be under. But I do want to remind Your Honor, there has been a sufficient cooling off period because this happened in December. There's been absolutely no testimony presented to Your Honor that there has been any contact between my client and Melissa since this alleged incident. So because of that, I am asking Your Honor to consider a bond no more than $2,000 in each matter, if not a signature bond under pretrial, where if Your Honor would to grant a signature bond through pretrial services, my client take a parenting class, if you were to take an anger management class, or even if Your Honor were to be inclined to a low bond with any conditions of classes, including anger management, we would ask Your Honor to consider that. Thank you.
All right. Mr. Spellers, I'm sure your attorney will tell you to put your hand down. And I'll let PD Armstrong, he has his hand up.
I advise you to not talk right now.
All right. I am going to give my ruling on the first case, position 10. I'm going to.
Excuse me, Your Honor, your attorney.
You're only hurting yourself right now, sir. Please do not talk.
I mean, I understand that, ma'am, that you're representing me, but I feel that it's key notes that you have left out. And I really would like to address the matter at hand while Melissa and the judge and the public defender is, I believe it's key things.
You wish to represent yourself?
No, ma'am, but what I told you on the phone, you have literally left that out. And I really felt that that would be important to the judge and the DA at the matter at hand. I have not pulled up or tried to contact Melissa physically at all, harmfully or threatful since this incident. Now, has she reached out to me? Have I returned calls? Yes, it has. Has it been violent? No, it has not. I have no kids with Melissa. I don't want to do Melissa any harm. I work Monday through Friday. I've been out of prison for 8 months after serving a 10-year bid. Since then, Melissa knows that I work Monday through Friday. So any altercation that we did have after the altercation in October, yes, I did get into it with her. I put my hands on her in October.
Judge, I'm going to ask that to be removed from this case. My client's acting as his own
was charged for that. I bonded out. Any situation after October was hearsay of what somebody thought I did. Even after these incidents where she called the police, we have talked. It has been no problem or nothing. She's not tried to come see me. I have not tried to come see her. I am not a threat to her. She's not a threat to me. She knows I have a family. She knows I have a child on the way. It's very important for me to go to work. I do not go out there. She knows I have my own apartment, my own job. My fiance has her own. There's no need for me to contact Ms. Sconius. I have not contacted, threatened, or did anything to Ms. Sconius in any way.
Okay. All right, you have expressed that, Mr. Spellers. But you need to tread careful. This is not your trial. This is a bond hearing. And so what I'm going to do on the first case of simple battery, family violence, that offense date is December the 3rd, 2022. And I understand there may not have been any incidents since that date, but that is the offense date that I have here. I'm going to order on that case a $10,000 surety bond. I'm going to order a stay away. I think from the 3000 Stonehogan connector, or do I not need to do that?
You
I
don't need to do that. She
don't
also
need to do
resides
that.
here.
But I'm going to order that you have no further contact with Melissa Sconius, and that means no phone calls, no internet, no response to calls. You to stay, I believe it's 200 yards away from her. You're not to contact her through any third parties. You're not to reach out on social media or anything with her. And so no third party should contact her on your behalf. So I'm warning you about all of those ways of contacting her, and none of them should you be able to do while you're out on bond. I'm going to order no drugs, alcohol, or weapons while on bond. And also no further contact with her 7-year-old daughter as well, a minor. And if we need to just put her initials in there, we can do that, but I don't want her to be contacted by you as well. What are your daughter's initials? Ms. Sconius?
You'll need to unmute yourself, Ms. Sconius.
TL.
TL. T is in Tom.
I mean,
L.
I'm sorry, TA. I'm sorry.
C is in Charlie. A is in Apple.
T as in Tom, A as in Apple.
Oh, T is in Tom. A is in Apple. Okay.
Mhm.
And no further.
And then I
contact.
also have a 17-year-old too. Hers is T as in Tom and S as in Sam.
Okay. Has he tried to contact her?
No.
Okay. I don't want to add to it unless you feel like you need that in order to feel safe.
Okay. You can add it.
Okay. So no further contact with Ms. Sconius' children, minor children, TA and CS. All right. The second case with the criminal trespass and damage to property on December the 14th. I'm going to order a $1,000 surety bond. I'm going to order no drugs, alcohol, or weapons while on bond. And I'm going to, again, order that there be no further contact with Melissa Sconius and her 2 minor children, TA and CS. No drugs, alcohol, or weapons while on bond.
I'm sorry, Your Honor, just to make sure, is it T as in Tom S or C as in Charlie S? I thought I heard
Ms.
T as in
Sconius, yes.
It's TS. T
Okay.
like in Tom.
Okay.
Oh, okay. That was my fault. Sorry about that. All right. So we have those correct. You have those, Ms. Bridgewater?
I do.
All right. Thank you. All right. That'll conclude both cases.
Position add-on one.
We have an add-on?
We have an add-on?
Well, we was told he was supposed to add it on, somebody named Maceo Baker. Y'all don't have, I can go to position number 4.
No, I don't have that.
I spoke to Mr. Baker. He was on the pull sheet. I was actually just asking if he was on the calendar, but
And
he's not on the
I was,
calendar.
I was just made aware of Mr. Baker. Can we hold off on him? Because I have nothing filed. I don't have an accusation done or anything. I would like to at least look at the case before we move on to him. Because we don't have any earnest. I just became aware of his existence like about 5 minutes ago.
And we don't have anything neither, Judge.
Number 5.
Yeah, he was on the bullshit. Okay, who we going to?
Position 4 and 5.
Hewitt.
All right, this is 23 CR 002491Y. Hunter Hewitt, charged at 1 count of theft by receiving stolen property on February the 12th, 2023. And position 5 is 23 CR 002493Y. Hunter Hewitt, charged at 1 count of theft by receiving stolen property, and that offense date is March the 1st, 2023.
16, 16 total. Last arrest was last month out of Hinesville, Georgia. Forgery, 2 counts. Theft by taking. He got an open case in state court for theft by receiving. It's 23 CR 001-442Y. Got an open case out of Baldwin County, forgery, 4th degree, 3 counts. Glenn County, financial transaction card fraud, forgery, 4th degree, 5 counts. And another forgery. On probation in Liberty County, forgery, 4th degree. Resident of Waycross, Georgia. We got a holdout of Milledgeville. 2018 fade to appear. 2018 ID fraud conviction. 2018 forgery, 4th degree conviction. 2017 criminal damage to property, 2nd degree conviction. That's it.
All right, thank you. Deputy Falk.
Yes, Your Honor. This incident happened March 9th, 2023 at 907 Holcomb Bridge Road in Roswell, which I believe is the La Quinta Inn. Officers were conducting an investigation on an entering auto and executed a search at that location. The defendant was the owner of the room, an iPad mini belonging to Brandon Williams, and a camera belonging to Michael Pulaski, along with several other stolen items were located inside of a suitcase, also including several credit cards and bank cards. The defendant initially claimed the camera belonged to him, but it was later determined that the camera was stolen. I know that the defendant did go to felony court today on an entering auto. I don't know if pretrial knows if he got a bond on that case or not.
I'll find out.
Okay. But in the meantime, the defendant does have a number of convictions starting in 2019 for forgery, theft. He has several arrests in 2021 in Glenn County for forgery, financial transaction card fraud, Baldwin County forgery, 3 counts. March 10th, he got a $1,000 surety bond from Judge Williams, where she signed it on March 11th for theft by receiving. And then April 20th, 2023, he had a conviction for forgery, 4th degree out of Liberty County. And let me not misspeak. All of these are arrests with the exception of the 2019 conviction for identity theft, theft by taking, and financial transaction card fraud out of Pierce. The defendant already has a $4,000 surety bond in this case already set, $1,500 on the 491Y case, and $2,500 on the 493Y case. We're asking that remain as set. He also has a foreign hold from Baldwin County. We're also asking for no further contact with Michael Pulaski or Brandon Williams. I don't believe he knows them, and an anti-theft course. That's all.
Give me the bond amounts already set again.
It's $1,500 on the case ending in 491Y. And $2,500 in the case ending in 493Y.
All right, and the names of the victims for no further contact.
Michael Pulaski and Brandon Williams.
Okay.
All the common spelling except for Pulaski is Pulaski.
Got it. All right, thank you, Deputy Armstrong. I'm sorry, PD Armstrong.
I'll take deputy.
I'm advocating for a raise. There we go.
Mr. Hewitt, it's he was very candid with me that there's been some concerns about drug use in his life, and he is, well, he was in a sober living house. I believe, Mr. Hewitt, please correct me if I'm wrong. It was Apex Living, Apex Max, but he was paying for that out of pocket as he was working as a pool technician for Sweetwater Pools. He's doing that for a little over a year. I'm not sure if there would be any way that we could, given the hold, what I envisioned was asking Your Honor if he could be released on bond to, with a special condition that he go back to the sober living facility and remain there for as long as he can, or until this case is resolved. But I'm not sure how that would shake out with the hold. But if Your Honor is inclined to release him to the hold, but with the special condition that he go to the sober living once he wraps up his business in, I think it was Liberty County.
And Your Honor, according to pretrial, it looks like he's got a $10,000 ankle monitor, $10,000 surety bond with an ankle monitor on the entering auto case that went today.
Okay, that's what happened today. Okay. Don't know if I have much leeway here. The first case ending in 491Y, I will order the $1,500 surety bond, believe that's already existing on that case. No further contact with Michael Pulaski and Brandon Williams. No drugs, alcohol, or weapons while on bond. I mean, for what it matters, I can put in there that after his hold, he can go back to that sober living house, but I don't know that I can even order that or state that, because it'll be up to them whenever that is, and I guess whether there's availability. Hopefully he will do that on his own and be able to get back in once
Your
he's
Honor,
cleared these.
and sorry to interrupt, the state wouldn't want that to be a condition, because if he's unable to fulfill that condition, that'll just bring him back to jail. So I'd rather it be
Leave that off.
we mandate. Yeah.
Okay, that is not a condition, Ms. Bridgewater. So he'll have to clear his holds first. The second case ending in 2493Y, I will order a $1,500 surety bond on that case. And again, looks like a stay away from the La Quinta Inn. No drugs, alcohol, or weapons while on bond. And I think that is it. Anything else, counsel?
No, Judge.
Okay, all right, thank you.
Thank you. That actually concludes my business. I'm happy to stay just in case y'all might need me, but just making it clear that I don't have anything left. So
Nothing left. What are we
Nothing.
doing on this Baker case?
I believe that's Ms. Bronstein's.
Is that Bronstein? Okay.
I
All right,
have
thank
the
you.
warrants. I can make it work. And then I'll go back, Ms. Bronstein, in court. I can go back and accuse the case once we have a once we have a SG number, I can go back and accuse it. But for right now, I can go ahead and do the bond hearing. As long as pretrial has the history, because I do not have it.
Right. What was position 6? Brandon Hutcherson?
Showing they were released.
He bonded
Released.
out. Yeah,
Okay.
$1,000 surety bond.
Okay. All right. And are we holding for a second on Mr. Baker? That's Mr. Baker in the chair, is it not?
Baker's in the chair.
You said Baker is in the chair. I didn't hear you.
Yes.
Okay. You'll have to give me, I don't have any information on him as well. His case number.
In Your Honor, we don't have case numbers on him. We have warrant numbers.
Oh, he's still under warrant.
We haven't been able to accuse the case yet because I just heard about him.
All right.
So
Warrant.
let me ask this here, since we have no information and I don't have any information to send over to the jail. Wait a minute, let me start. Hold on. I'm just curious as to what will happen.
Mm-hmm.
So, I mean, he could, if we agree to a bond and the paperwork is sent over to the jail, they'll have the jail information Your Honor orders a bond, no differently than would happen in magistrate court. The state's real concern here is we can't kick the can down the road on this. He was arrested on the 20th. It's a Riverside issue as of tomorrow.
Right. So we have to go ahead, right?
What's the charge?
Loitering and prowling, let's see. 2 counts of loitering and prowling and 1 count of expired driver's license. So.
I got the history though. Y'all ready?
Okay.
Whenever.
Right. All right, go ahead, pretrial.
This is 9th arrest. He got an open simple battery family violence, 21 CR 002 0. Yeah, they missing a case number, but it's in state court. 2020 probation, 2019 battery DV conviction, 2006 simple assault conviction. He went to felony yesterday and got a $5,000 bond. That's it.
All right. Deputy Falk.
Yes, Your Honor. Okay, so this incident happened, bear with me, April 20th, 2023 at 2922 Ridgeview Drive, Atlanta. Oh, I think I see what the issue may have been with this one. So the defendant was charged with theft by receiving stolen property, felony, and it happened on the same date at around the same time as my loitering and prowling cases, where he was driving in a stolen vehicle. And I believe pretrial said he went to first appearance on that case yesterday. I think what may have happened here is they separated off. They did. This is the same officer took out all of the warrants. And let me just check the case numbers here. And it looks to be, they are different case numbers, but the same officer took out the warrants and they were within an hour of each other. As far as the incident time and date, and the location is right near the location of the theft by receiving stolen property. So I think the reason this may have gotten lost is because those warrants were technically supposed to be attached to the felony and go with the felony and got detached from it. So I don't know how Your Honor wants to address it with that new information. Obviously, he's going to get a bond. Even if we kick the can on this to Monday and send it to felony, what I would say is I'm still prepared to go forward with the bond hearing, have him get a bond and on the remaining charges, and then I can send that case up to the DA's office to reattach it with the felony. Ms. Braunstein, do you have any, you want to weigh in on this one? Oh, sorry, you're muted.
You're muted.
Sorry. Defense is ready to go forward on the bond hearing today.
Okay. We can. Anything else, Deputy Falk?
Yeah, I'll just give the facts. So
Okay.
April 20th of 2023, officers were flagged down at 2934 Ridgeview Drive regarding a suspicious person. The officers were informed that the defendant was driving a white vehicle circling the neighborhood at a high rate of speed. The officers then were able to pull the vehicle over at Riverview Drive in Meadowstone Lane, asked the defendant why he was driving so fast and what he was doing in the neighborhood. He claimed he had 3 apartments in the neighborhood consisting of only townhouses. He also claimed his sister lived in a gated community. He couldn't provide addresses for either one of the claims. He was asked for his name, stated it was Joe Simpson initially, but then changed it to Josh Simpson, and gave the date of birth of December 27th, 1985. The officers then detained the defendant and was shown a video by a neighbor, Miss Drakia Tate, showing the defendant parking in her driveway and attempting to open her front door. At that point, he was placed under arrest. They also made contact with Mr. Corey Love and Najere Dade, who both live in the gated community, and stated they had video footage of the defendant entering their backyards at 2934 and 2922 Ridgeview Drive. They also observed the Ford Escape that the defendant was driving was an ATL Plus vehicle. The officers called ATL Plus and confirmed that the vehicle was stolen. A city-issued fingerprint scanner was then brought to the location, and once they did the fingerprint scanner, it confirmed that the defendant was Macio Baker. The defendant is currently, just go back and look at something real quick, currently on a $2,000 surety bond on the loitering and prowling each. $2,000 on expired driver's license. Apparently, once they ran his driving history, once they determined who he was, it showed he had no license, and a $1,000 surety bond for giving false information to the officer when he told the officer that the false name and false date of birth. The state would recommend a total of a $6,000 surety bond. We're going to ask to keep the $2,000 on each of the loitering and prowling, reduce the expired driver's license to $1,000, and leave the giving false information at $1,000 for a total of a $6,000 surety bond. Stay away from, and I will put the names and addresses in the chat. Stay away from the victims at 2922 Ridgeview Drive, Atlanta, as well as 2934 Ridgeview Drive, Atlanta. Those are the residences of Mr. Corey Love and Nijere Dade. We're also asking that he have no alcohol, drugs, or weapons, as well as no further contact with those individuals and no further contact with the witness who spoke to police initially, which was, it just says concerned citizen, so I don't have a name for that individual. And also Miss Jerika Tate, who is the person who showed the officers footage of the defendant pulling into her driveway and attempting to open her front door. That's all for the state. Also, we would recommend a BHET, just based on some of the statements that were being made to the officer. We do have some concerns.
Okay, Ms. Bronstein.
Thank you, Your Honor. The Public Defender's Office is going to represent Mr. Macio Baker. He is 36 years old. He is from Atlanta. His family, his mom, his grandmother, his siblings, they're all in the area. He did graduate high school back in 2003. He does work. He has worked for the same company for 3 years, transporting cars. The company is Eris. I do understand the other pending case and the criminal history that pretrial recited. We are requesting a $1,000 total bond, $400 each on the loitering, signature bond on the expired driver's license, and $100 on the false name.
Okay. All right, I'm going to order the $6,000 surety bond, which is $2,000 on each of the loitering and prowling, a total of $4,000, $1,000 on the driver's license, and $1,000 on the false information, for a total of $6,000. I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to order no further contact with the victims?
Yes, Your Honor, no further
Corey
contact.
Love.
And I did put that in the chat to Ms. Bridgewater, no further contact with Corey Love and Nijere Dade and Jerika Tate, and stay away from 2934 and 2922 Ridgeview Drive Southwest.
All right. Those will be the other conditions in there as well, in that order. Anything else, counsel? No drugs, alcohol, or weapons on bond while on bond? Not sure if I said that.
Other than the BHET, Your Honor.
Oh,
I don't know if
BHET.
PD Bronstein observed anything that may give rise to it, just based on some of the statements that were being made to the officer at the time. The state had a few concerns.
Nothing was immediately apparent to me upon speaking with him.
All right, I'll still order the BHET due to the history and what I've heard here today.
Let me get this right. Miss Attorney Paul, you're going to give me the accusation number so that I could do this, or you're gonna give me warrant numbers? How are we gonna write this bond order up?
I can give you warrant numbers, being that I'm positive this case needs to go with the theft by receiving and does not need to be bifurcated. We're like literally walking ourselves into a double jeopardy issue if we keep them separate. I'm going to send you the warrant numbers, and I can attach the warrants and send them to you so you have all the warrant numbers. And then I'm going to request the DA's office today go ahead and take the rest of the misdemeanors along with the felony and assign it all under the same CP number.
Okay.
So that's the plan. Ms. Bridgewater, do you see anything that might cause issues with that?
Yeah, hold on one second. So I have a total of 4 charges here, 2 for the loitering and prowling, 1 for the expired driver's license, and 1 for giving false info.
Yes.
Okay, that's the way I'm gonna do this bond order up. And you're gonna send me those warrant numbers. I'm gonna put that on the bond order. And this is gonna be a total of a $6,000 good bond,
Yes.
okay?
Yep. That sounds
Okay.
right.
Okay, and I have all the conditions, so I'm gonna do this order separately from what's on my calendar today,
Mhm.
okay? So that we're all on the same page.
Yes.
Sounds
And I
good.
just emailed you the warrants.
You emailed it to me, okay,
Yes. So
okay.
if you, and when you receive it, if you could confirm you have them, then I'll square that away.
Okay. Okay, so with that being said, my calendar for today is ready to go over, and I'm gonna do that bond order up, and we should be complete.
Okay. Sounds
Are we on
good.
the same page as far as that's concerned?
Yes, ma'am.
Okay, all right then. So are we ready to go over the calendar then?
Think so.
Is there something I'm missing, or are we ready to go over the calendar?
We're ready.
Okay. All right then. So once again, the reset date for the SAP calendar is going to be May 4th. Position number 1 is reset further notice with a $3,000 SOB through the jail. Position 2 is going to the SAP calendar with a $500 good bond. Position 3 is reset further notice with a total $3,000 SOB through the jail. Position 4 is going to the SAP calendar with a $1,500 good bond. Position 5 is going to the SAP calendar with a $1,500 good bond. Position 6 is reset further notice as the defendant has been released. Position 7 is going to the SAP calendar with a total $5,000 good bond. Position 8, SAP calendar with a total $4,000 good bond. Position 9 is going to the SAP calendar with a total $6,000 good bond. Position 10 is reset to the SAP calendar with a $10,000 good bond. And position 11 is going to the SAP calendar with a $1,000 good bond. Are there any questions, comments, or corrections?
Nope. And your little add-on.
Well, with the add-on, I'm just doing that separate because I don't have a calendar to do that. So I'm just going to send the bond order over
Okay.
to the jail.
Sounds good. Mm-hmm. Sounds good.
Okay. Is there anything else?
That's it.
Okay.
All right.
Okay,
Everybody have a good weekend.
Indeed, indeed.
Thank you, everyone.
Okay.
You too. All right.
All righty.
Bye.
Bye-bye.
Ms. Bridgewater, if you're still on here. Oh, I think she already left.